So we spend so much time talking about settling your case, how to settle your case, how to get the most amount of money. And it's a bright, juicy topic. Everyone loves talking about money, settlements. But MMI is it's the precursor to your settlement. It's the most important part of your case that leads up to the settlement, and it's what you need to know when you're coming down to maximizing settlement value. So today we're going to talk about the perils and pitfalls and what you need to look for when settling your case. The top 7 workers' compensation MMI mistakes that can cost you thousands. And we're going to dive right in. So I see the comments. How's everybody doing today? I love it. Post all your questions and comments. We're going to try to get to everybody and answer all your questions today. But let's jump in with these with our discussion about MMI. What is MMI? Well, and why is it such an important part of your workers' compensation case? Well, first and foremost, before we do anything, we really need to understand what is MMI. MMI is maximum medical improvement. MMI is when you've recovered to the point where your doctors think you're not going to get any better. You've plateaued. There's no other treatment that they could give you that's going to improve your condition. And sometimes, it comes down to surgical issues. There's a lot of people out there that don't want to have surgery, that are afraid of surgery, that for whatever reason, could be religious reasons. We've had clients that decline surgeries for religious reasons. But for whatever reason, if you're at the point where your doctor's saying you need surgery and you say, I'm not having surgery, well, maybe you're now at MMI, or maybe you had your surgery and you've recovered from your surgery and you've gotten as good as you're going to get. Maybe now you're at MMI. MMI is maximum medical improvement. It does not mean that you're 100% better. It does not mean that you're fully healed. It does not mean that your case is over. You can reach MMI and still be very severely disabled. It's just that point where your level of disability is no longer fluctuating. You've reached a plateau. You've reached a point where you're not expected to move up or down from that level very much. Now, before we go any further, it's super important with a workers' compensation case for you to understand and distinguish what type of injuries you have in order to determine which way your case is going. You have to distinguish between scheduled loss of use injuries, which we've discussed in the past. Scheduled loss of use injuries generally are injuries to your arms, legs, hands, feet, fingers, and toes. It can include hearing and vision, but generally they're extremity injuries, your arms and legs. Versus non-schedulable injuries. And your non-schedulable injuries are really what we're going to focus on today. Those are your head, neck, and back injuries. Back injuries are rampant. There's so many back injuries. It's probably the most injured body part overall, which is why we're going to spend so much time discussing non-schedulable injuries, which result in permanent partial disabilities generally. It's super important to understand. You have to distinguish between what injuries you have. And when you have injuries that are in both categories, we really need to look at other factors in your case. Have you gone back to work? Which injuries are the most significant? There's certain factors you need to look to, which is why it's important to have an attorney that understands the ins and outs of the workers' compensation world so they can maximize your claim value and get you as much money as possible and allow you to have a good cushion so you can move on with your life and put us behind you and forget about the nasty workers' compensation world. But please understand and make sure you know it's clear which injuries you have. Schedulable injuries, non-schedulable injuries. It's super important. Like I said, we're going to run through the non-scheduled. We're going to focus primarily on non-schedulable type cases for the purposes of this discussion. But at the end, we are going to talk about how MMI impacts schedulable injuries to your arms and legs and hands and feet and how to maximize value on those as well. When you've reached maximum medical improvement, so you get hurt, you have your accident, sorry, and you get hurt. Generally, you're totally disabled following your accident initially. And as time goes on and you get treatment and physical therapy and chiropractic care and so on and so forth, your injury gets better. Doesn't mean it gets 100% better, but you do recover from your injury as time goes on. You do heal. You do get better. Treatment is there to help you. And as that time goes on, you eventually reach that point of maximum medical improvement. Once a judge determines that you've reached maximum medical improvement, or your doctor and the insurance company doctor agree that you've reached maximum medical improvement, your temporary benefits usually stop around that point in time. And you kind of move into the permanent disability phase, because MMI is the precursor, is the beginning of the end. It's the beginning of determining permanent disability. So around that time is when your temporary disability benefits will come to an end and your permanent disability benefits hopefully will pick up. Sometimes, and sometimes you won't even realize there's a difference. Sometimes the judge will make a finding that your permanent level of disability was the same as your temporary level of disability just before that decision was made, and you'll be getting the same amount of money straight through, and you won't even know the difference. Sometimes, if you have a good lawyer like me, we're able to argue that your level of permanent disability is greater than the money that you've been receiving up until that point, based upon whatever level of disability was determined up until that point. So maybe you've been getting paid at a 65 or a 50% rate of compensation, and we're able to prove that you have a 75% permanent disability. Well, maybe your money's going to go up once permanent disability has been assessed. And by the same token, with the good, there comes the bad, and there could be a finding that your level of disability has decreased and you might actually get less money. So once that transition is made, oftentimes there could be a change in your compensation. And the worst part of it, in circumstances, especially where work search has been required, and we've discussed this in the past, and we'll touch on it briefly at points today. But when your doctors have determined, or the judges determine, that you have a partial disability just before you reach that stage of permanency finding, sometimes you are required to do a work search. And if your work search isn't sufficient, a judge might suspend your benefits. And you get nothing until you could prove that you've done a good work search and convince them to start your benefits up again. So it is something that happens, and it's a tricky tool. And I'm sweating. I'm going to put the AC on. There we go. It's a little tricky tool that insurance companies pull very, very often. What'll happen is you're getting your temporary disability benefits, and your doctor has maintained all along that you have a total disability, a total disability, a total disability. You haven't gotten much better. And the insurance company doctor says, well, maybe you have a 75% disability, and that's gone down to a 50% disability. And they are arguing that you have a partial disability, and you've been getting compensation benefits, temporary benefits, which have been payable at what we call a TR, or tentative rate. So there has been no determination as to your fixed level of disability. Basically, we're saying it's 100, you're saying it's 50. We're going to reach some compromised rate while you're hurt and while you're temporarily disabled. But once your doctor files that C4.3 form, and we're going to talk about this more as we get further in, the doctor is required to check off what your work capacity is. And unfortunately, on that form, there is no, as far as I know right now, there used to be, and they took it away, and I don't think they've ever put it back. I think there was discussion that they might, but there's no, there's check boxes for heavy work, very heavy work, medium work, light duty work, sedentary work, less than sedentary work, but there's no checkbox for total disability, no work. So your doctor is kind of forced to check off a box, and unless he puts in a really nice narrative report saying, I'm checking this box only because there's no other box, and my patient is totally disabled, your doctor's checking a box saying you can do some work. And insurance companies will jump on that and say, well, now you're partially disabled. Now you have to go look for work. And they attach you with this work search requirement. And if you don't do a good work search, it could hurt you, and your benefits can be suspended. So you got to be very, very careful at this point in time, super careful. You don't want that to happen. Make sure you have a good lawyer. Call me if you need. 212-406-8989. This is where we see the biggest mistakes in cases. This is where problems pop up. Also, missing deadlines, rushing settlements, losing out on benefits. This is the point in time where those bad things happen. The system gets less forgiving after you reach maximum medical improvement, and insurance companies know how to use it to their advantage. And this work search attachment requirement is just like one of those things that they're going to use to try to hurt you. So we're going to walk through the top mistakes that people make at this stage and what you can do to avoid them, to preserve your rights, preserve your benefits, preserve your money, so you could live your life and get through this system and move on with your life. What are the biggest MMI mistakes injured workers make in their workers' compensation benefits, in their workers' compensation case? What are the biggest mistakes you can make? Number one is assuming your benefits continue automatically after you reach maximum medical improvement. So, and this is exactly what we were just discussing. People think, well, I've been temporarily disabled for so long that at this point in time, now that my doctor's found me at maximum medical improvement, I'm going to get more money and it's going to continue. And I'm permanently disabled now and I don't need to do much. It's just going to, this is just going to progress on its own. And that's wrong. Maximum medical improvement findings end your temporary benefits and they don't continue just by default. It just doesn't happen that way. To keep getting paid, you need to get a permanent disability ranking from your doctor. And God forbid, if work search has been required, you need to do a good work search. And we've done videos on this in the past, and I think we need to devote an entire video to work search and the requirements and what you can do to get through that part of your claim. Your doctor has to file a form. It's called a C4.3 here in New York State. It's the workers' compensation form where MMI is assessed, and the doctor has to articulate his reasons for why you've reached maximum medical improvement and what his opinions are with respect to your permanent disability. It's a very simple form. Doctors fill them out all the time. You could find that form on the board's website. In the form section, you can peruse it yourself so you know what your doctor needs to answer. You can bring a blank one. My clients do it all the time. I give them blank 4.3s. Here, take a look at this. Get comfortable and familiar with it. This way, if you have questions, go ask your doctor. When you go speak to him, bring the blank form. Hey, it's asking me, have I reached maximum medical improvement? It's asking me, am I able to do my pre-accident job with or without restrictions? Let's go through this, doc, and you're more than welcome to do that. The form's on the website. Super easy to find, super easy to follow. It's a very easy form. Take a look at it. Excuse me. It's not always automatic. Your doctor is supposed to file that form when he finds that you've reached maximum medical improvement, but it's not always an automatic thing. Many doctors don't do that for whatever reason, and oftentimes it is directed by the law judge. The judge will say, claimant to produce a C4.3 within 60 or 90 days or whatever it is, both sides to produce permanency. If a judge sees a case has been just lingering for years and years, he might just want to know where we're at medically. Both sides produce maximum medical improvement documentation. And on that C4.3 form, the doctor can check. There is a box before anything else that says, has the patient reached maximum medical improvement? Yes or no? If no, explain why. So the doctor can check that box, say my patient has not reached maximum medical improvement. These are the reasons why, and there you go. So at least it satisfies the board in that you produce the form that they're asking for, and you're able to move forward without getting caught up in a little bit of a web there. If there's no C4.3, then you have no rating. You have no rating of permanency. If there's no rating of permanency, then it's very possible you get no permanent benefits, or you're stuck with the findings that the insurance company's doctor has made, and you might not want that. You usually don't want that. What other mistakes? Ignoring the insurance company's report of MMI, and that's what we were just talking about. You go to see their doctor. They examine you, whether it's 2 minutes or 20 minutes or an hour. They are going to send you a report explaining their findings and their conclusions. Oftentimes, and not always, but oftentimes the insurance company doctor will conclude that you've reached maximum medical improvement before your doctor. If that happens, usually what happens is once the board receives that medical report, they issue a notice to the parties, to you and your lawyer, and they say, we've received this report that's giving a permanent disability. It's time to get yours. And they usually give you 30, 60, 90 days to respond, but you're now on the clock to go get your own report from your own doctor. And if you don't get it done in the time frame they tell you, you are jeopardizing your claim, because they could preclude you. They could make a finding that you are precluded from producing that report, and now you're stuck with what their doctor has to say. And hopefully your lawyer can do a good job showing that it's worse than what their doctor says, if it is in fact true, but you don't want to be stuck with that. It puts you in a really bad spot. The insurance company's report will then control your case for the most part, and you don't want that. It will affect how you get paid, the amount of benefits, and for how long you get them. It goes right to your disability ratings. Disability ratings tell us how much you get, how long you get it for. And you don't want their doctor to be the one driving the ship there, because it's going to hurt you. Your own doctor should submit his own report giving his opinions on your permanent disability, whether you've reached MMI or not. And if so, what he feels your level of permanent disability is. And if there's a conflict, as there so often is, the board will either administratively, they'll send a letter out and they'll say, hey, there's a disagreement here as to the level of permanent disability. Take depositions of all the doctors that you want and file your arguments. And either they'll give you a hearing or they'll file a reserve decision, which they do outside of the presence of the parties. But oftentimes you get a hearing and it's judge, their doctor says this, our doctor says this, and you either try to work it out. And if not, you go to depositions and you litigate the case, try to show that their doctor was wrong and your doctor was right and that your disability is more severe, and try to get you the benefits that you are entitled to. If their report goes unchallenged, if your doctor fails to file the 4.3, the permanency report that he's so required to file, then their numbers are going to shape your case. Their findings are going to be what we have to use to determine the value of any settlement that we might be looking to do, which is why this is such a crucial point in your case. The point just before and just after, right around that maximum medical improvement finding, is the most important time in your case. And oftentimes I find it's the best time to try to settle a case. And we're going to talk about it why. But before those formal findings are made, before you're locked into those numbers, there's still some ambiguity. There's still there's an argument to be made about how severe your injuries are, what your case is worth. And I find oftentimes it's the best time to jump on a settlement and try to get that case resolved. If you don't challenge the insurance company's doctor's findings with your own doctor's findings, you're going to get stuck with them. You don't want to be stuck with them. And the board is not very lenient when your doctor fails to file those reports in time. They want to move their cases along. They want to keep their calendar moving. And oftentimes they will not give you a second bite at the apple if you miss the first. So make sure you keep those deadlines in mind. Make sure you make those appointments as soon as possible to go see your doctor. One huge mistake, that we see all the time is we get a notice from the board, claimant to produce permanency report. We receive the insurance company's IME report, and you have 60 days to produce your permanency report. You have 2 months to go see the doctor and to get an assessment on permanent disability and get it into the board so we can move your case forward. And people say, all right, I'll get around to it. I'm going to go see my cousin next week. And maybe when I get back, I'll call the doctor and I'll make the appointment. You don't understand how busy doctors are if that's how you're taking this. As a lawyer, if I have a person who's coming in who's bleeding out of the eyeballs and I try to do a favor and get a doctor's appointment as soon as possible, I can't get it done within a few days' time. Doctors' offices are busy. They're crazy busy. Doctors have multiple offices. They go see patients in different places at different times. And getting an appointment in time for them to then draft a report, have it transcribed, have it issued, have it billed, and sent to the board, 2 months is not a lot of time. It's not a lot of time. So once you get that notice that you have to go get that report, you better be on the phone with your doctor that day or the next morning scheduling your appointment. Don't sit on it. Don't wait because it's only going to hurt you. Get the appointment done. Go see the doctor. Get it taken care of. And don't be one of these people that are straight. It's the kid who waited till the night before to do his homework. And unfortunately, the board is not as nice as your kindergarten teachers. So don't put yourself in that position. With that rant, I'm thirsty. Moving along. Oh, my slides are stuck. Sorry, I'm having a problem with my slides. Slides 3 and on are not loaded. So we're going to talk about them, but I can't get, let me just make sure it's not, nope. I only have slides 1 and 2. There's no 3 through 8. We have 8 beautiful slides. There's only 2 slides. Okay. Lovely. So, what else is there? What's the next? Well, let me bring that back up then. What's the next big mistake? Not showing that you're attached to the labor market after maximum medical improvement. And this is what we talked about earlier. This is probably the biggest pitfall. This is probably the biggest danger. This is probably the biggest hazard to your case, which pops up at the end of the case. So what happens? You get hurt, you're getting your temporary benefits, money's coming in. It might not be a whole heck of a lot, but it's money to that you can sustain yourself on, and you can put food on the table and pay the rent and pay for your car. And some money's coming in. And now a year, 18 months, 2 years into it, you're at this MMI stage and your doctor files a report. And what does that report say? It says, my patient, Mr. Whoever, since we're Met fans here, Juan Soto has a permanent partial disability. And I believe that he has a class, and I'm going to be speaking French for the next few seconds here because whatever. This is how the board does it. But for his neck injury, he has a class 3 severity ranking of C. And for his low back, he has a class 2 severity ranking of B. What does that mean? It's up for interpretation. And with those findings, I believe he's capable of medium work. Okay, so that report gets filed and we have a hearing. And what's the first thing the insurance company is going to do? They're going to say, Judge, his own doctor says he's capable of medium duty work. He is not totally disabled. We are raising labor market attachment. He needs to go out there and look for work within his restrictions. In the grand scheme of the legal world, we call this mitigating your damages. You can't just sit on your butt and let the damages build and build and build. If you're able to contain those damages by going back to work within whatever capacity you're capable of doing, you are required to do that. If your doctor says you're capable of medium duty work, you have to look for work that you can do. So you've now been sitting and getting checks for the last year and a half or 2 years or however long it's been since your accident. And now all of a sudden, you have to go look for work. You have to go put in a good faith work search effort and show the judge that you've done everything you can to try to get back to work, look for every job you can within your restrictions. And either you do and you find a job and that's great, and maybe you have a reduced earnings claim, or you can't. And you got to prove to the judge that, Judge, I've done everything I can and I just can't find a job. And you better hope the judge agrees with you, that the judge says, you know what? Yes, you have done a very good job. You've tried hard. You went to the local agencies like Workforce, invested, and you're doing everything you can to find work. And I agree, you can't find a job. And I'll continue your benefits. But if the judge doesn't agree, if the judge says, I don't think you've done a very good job, I think you're just kind of doing the bare minimum here and you might be BSing us, and I don't really think you went and knocked on all these doors like you say you did, well, then your benefits are going to get suspended. And regardless of what your level of permanent disability is found to be at that point, it's not going to matter because you're not going to get a single dollar from workers' compensation until you reattach to the labor market. And it's the worst place on earth to be with respect to a workers' compensation claim. And I see this happen with my clients from time to time. And we try to do everything we can to slalom through the claim to avoid this, but sometimes it's inevitable because, to be honest, not everybody's totally disabled. There comes a point in time where your injuries have settled and you've reached that point of maximum medical improvement and you're not 100% disabled. You're only 50% disabled, or you're 25% disabled, or maybe you're 80% disabled, but you're not 100. So you have to look for work within your restrictions in order to keep your money coming to you. And it's a shocking thing to have happen to you because you've been home and you've been treating and you've been doing the best you can to live your life with these injuries, which are turning out to be permanent injuries. And now you're being hit with the fact that you have to go look for work. I understand that it sucks. And I sympathize with each and every person that is subject to the work search requirement. But the law is the law. And as much as that I get yelled at for it, I can't believe this and you didn't fight hard enough for me. Well, it's not that. You're just not totally disabled anymore. And this is the requirement that the law has now. I hate it. It wasn't always this way. Maybe this is, how long has this been around? 15, 20 years, maybe. I'm dating myself, but it wasn't always this way. And I hate that this is now the law, and it stinks, but it's the law and you have to do it. So the work search requirement is the biggest. I should have red flags going all over the place here. Why does it become such a big problem? Like I said before, there is no total disability option on that C4.3. Your doctor has to really, really, really explain it. Oftentimes they attach a narrative report, a typed out full report, like a book report about your back, to that C4.3 saying, I know what the form says, and I did the best I could filling out this form, but this person is totally disabled for all these reasons. Even if the doctor checks sedentary work or less than sedentary work. Sedentary work is a sit-down job. Less than sedentary work is a sit-down job that allows you to move as necessary with no lifting over 5 or 10 pounds. It's like the bare minimum type of work. But that still means you could do work. So even if your doctor checks off less than sedentary, he's still checking that you can do something, and he's got to really make a very good pitch to the board as to why you remain totally disabled, if in fact you are totally disabled. Once there's a finding that you have a partial, you have to find jobs within your restrictions, suitable work within your restrictions. If you don't do a job search, if you don't do an adequate job search, then you risk your benefits being suspended until you do an adequate job search. So once MMI is coming down the pike, and you're seeing and your lawyer's telling you that you're going for a permanency evaluation, or your doctor's saying that a permanency evaluation was requested, this is something that you need to be cognizant of. And it's something that people get blindsided by more often than not, because you're not expecting it. You've been getting paid for your lost time. You've been getting paid for your disabilities, and you've been going to the doctor and you're doing everything. And now all of a sudden this nasty thing pops up that requires you to start looking for work within your restrictions. Be prepared to look for work when you're approaching maximum medical improvement. That's really all I can tell you. And it's just the way it is. And we've had discussions about this in the past, doing your work search. Keep records of your work searches. There's so many people that come in and say, yeah, I looked for 15 jobs this week. Okay, show me what you did. I made a bunch of phone calls. Did you keep a log of it? Take a piece of paper. Take a piece of paper and make a list. Okay? This is a point in time, and I can't stress this enough, and no one seems to recognize the enthusiasm I have here with this one particular thing. This is a time when you can make your own evidence to support you. I'm not saying you should make it up and lie, but if you go out there and look for 10 jobs, keep track of 10 jobs on your piece of paper. Print out those job postings from Indeed. Print out the email that you sent to the person at Target who is in charge of hiring the cashier position that you applied for. Print out his response that said, I'm sorry, the position was just filled, or I'm sorry, based upon the fact that you have an injury, we can't hire you. Print out your resume that you sent to them. Print out the application that you filled out. That one job application could result in 5 or 10 different pieces of evidence, and it's going to show that you're really doing the best you can, and you're just not able to find a job. Keep track of those job searches. Write down the phone calls you make. Who did you call? Who did you speak to? What phone number did you call? What time did you call them? The insurance company has a right to those job logs and that evidence, and they will follow up. They will call Mike at Mike's Deli and say, hey, 3 weeks ago, did Juan Soto call you for a stockroom job? Because he says he did. And if Mike says, I don't know what the hell you're talking about, that's going to hurt you. But if Mike says, yeah, Juan Soto called me, and I'm sorry, I can't hire a guy with 2 bum knees and a bad back to work on my stockroom. I mean, now you're looking for work that's outside your restrictions, but putting that aside, it'll help you to show that you were honest and you actually gave it a good try. Ooh, you got me going today, people. Next big mistake. Mistake number 4, settling at the wrong time. We touched on this before, and we're going to talk about it now. Settlement usually comes around the time of MMI. Why? Because there's still some question as to how significant the permanent injury is and how much money the insurance company is going to be responsible for. And when it comes to MMI, there's also a question that maybe you're not at MMI. Maybe you haven't reached maximum medical improvement. Maybe you do need another surgery that's going to cost a whole ton of money. And maybe you don't want that surgery. So right around that time where MMI starts rearing its ugly head, or beautiful head, depending on how you look at it, that's when you want to start getting into settlement discussions. When you're ready, you want to do it as quickly as you're ready before you reach maximum medical improvement, because there's still some uncertainty as to what that case is worth. Timing is really everything here. If you settle too early, you might miss out on some major value with your case. If you settle too late, if a judge determines that you've reached maximum medical improvement, let's pick a number here. Let's say he finds that you have a A 30% permanent disability. A 30% permanent disability gets you 250 weeks of compensation. Okay. So let's say after a year of being injured, there's a finding that you have a 30% permanent injury, 30% permanent partial disability. You're entitled to 250 weeks of compensation. If you sit back and wait 2 years, 104 weeks into that, well, now there's only 146 weeks of compensation left to you. How much is your case really worth at that point in time? You bought down your own case. You did get those weekly checks, but that big settlement check at the end is not going to be as nice as you thought. So you don't want to wait too long. The sweet spot is right around the time of maximum medical improvement, but before the judge finds your permanency rating. Once that decision is made, you're locked in. Yes, you can appeal a judge's decision. Yes, there's a possibility of it getting modified, overturned, reversed, whatever on appeal. But for all intents and purposes, that's when you get locked in. Before that hearing, your lawyer can argue that your case is worth more because there's still some uncertainty as to what your overall level of disability is. The insurance company does not know their full exposure. You could have a great lawyer that gets you a lot more money, and they don't know that. They don't know, what tricks you have up your sleeve. So that's the right time to do it. You don't want to wait too long, and you also don't want to do it too early. If you're going to do it early, you might as well do it at the very beginning, unless you really need some surgery or something. But that's why it's important to have an attorney. This is why it's important to have an attorney, because you can have this sit down. And I must have had this similar discussion with 10 people today. Yes, you're reaching that point of max medical improvement. What has your doctor said about your treatment needs moving forward? Do you want another surgery? Do you need another surgery? Are you willing to, do you really not want the surgery? You're scared shitless of having another surgery and you're willing to give it up, close your case and be done with this? Talk to me and let's figure out the best way to go about getting your case settled if now is the right time to do just that. I mean, I was feeling great and now I'm like, haha. Number 5, big mistake, accepting a lump sum settlement of Section 32 without a long-term plan. After you've reached maximum medical improvement, many insurance companies will offer to close out your medical, your overall case with a Section 32. And it might be nice to get a nice big fat check, but maybe you do need maintenance care, symptomatic care, we call it, long-term. Maybe you do need the ability to go back to see the chiropractor once every 6 months to get that back into shape. And if you settle your case with a full and final Section 32, the responsibility to pay for that is yours. And yeah, a chiropractic adjustment is not going to put you in the poorhouse. But maybe your orthopedist wants you to get a follow-up MRI every 5 years. Well, that's something you really need to consider. So you should talk to your doctors about what to expect if you do settle your case. A lot of times, clients will go and speak with their doctors and their physical therapists, and they'll say, hey, even though my doctor's requesting I go for a lot more physical therapy, the physical therapist taught me all these different home exercises I can do, which would help me. And that's a lot of the same stuff I do at physical therapy. And maybe it's a good time to settle my case and I can maintain myself with home exercise. And maybe that's a smart way of going about it. So you want to plan for it before it happens. You don't just want to take that money and run, because oftentimes that bad things happen. And that's when I get calls saying, hey, I'm out of money. What else can we do with my case? And I say, you settled, big guy, your case is done. So you want to prepare and plan for your future once you do settle that case. Have you accounted, I'm looking over my notes here, great notes. Have you accounted for the other expenses you haven't anticipated, MSA or outstanding child support? When we do a full and final settlement of your case, more often than not, virtually every time, we allocate money, if it's not required by Medicare, for your future medical care. So there's the percentage of money in your settlement that's there for you to use for your future medical treatment. When you are required to do so by Medicare, it's a formalized number that you have to set aside. You have to use for future medical care. But your settlement is in place for you to care for yourself, including your future medical, and there's money there for you for that. And make sure you plan for that. Make sure you plan for other expenses you have in your life, child support, things like that. If you take a lump sum, a full and final Section 32, once your case is closed, it is closed. It is closed forever. It is vaulted. It is sealed in stone. The only way a Section 32 can ever be reopened is if all the parties to that agreement, including the board, agree to reopen that case. And I have never seen it done with any of my cases and my clients. It is as good as it's Han Solo in the what's that stuff called? Someone's going to post it there. I forget. I was going to say tannerite, but that's what you shoot guns at and explodes. Carbonite. That's it. Although Han Solo does come back from the carbonite. The sixth biggest mistake we see when workers' compensation case clients settle the MMI mistakes. I'm tripping over my words here. Not keeping records during and after you've received you reach maximum medical improvement. Every form, every report matters. Doctor's notes, IME reports, letters from the board, decisions, and all those documents that you are collecting during your work search if you're required to do a work search. Your paperwork is your defense. Hold on to all your documentation. Here at our office, let me show you. Every client who comes in, every new case gets a little folder, and they put, Catherine's laughing at me because I'm showing the folder. Here's a folder for you. Keep all your paperwork in a folder. Keep it all in one place. If you have a lot of paperwork, if you have a really cumbersome case, we'll give you a bag. We'll give you a tote bag. Even if you have a little case, we'll give you a tote bag. If anybody wants a tote bag, come and ask me. I'll give you one. You also get, everyone gets their complimentary Rex Sikowski pen when they come to see me. But we give you a folder. Keep your stuff together in a folder. Keep it in one place. If there's any disputes, any problems, any inconsistencies, bring your folder to me. It's fine. You know, we do it all the time. I'd much rather go through paperwork in a folder than going through unopened and half-opened envelopes in a Chinese food bag with duck sauce dripping off the side. But that's happened too, and I'm happy to do it. But keep it in a nice, neat folder, please, and thank you. Now, another big mistake. People assume oftentimes that once a finding of maximum medical improvement, MMI, is made, that there can't be any discussion as to a change in condition. They don't want to be locked in because what happens if my condition gets worse? And it's a very valid concern. If things get worse, you might be able to reopen your case. If you've settled with a Section 32, not so much. But if you have reached that point where you've reached maximum medical improvement and a judge has made a determination that you have a 50, 60, 80, whatever percent permanent partial disability, you might be able to reopen your case for additional ongoing active treatment, not symptomatic, maintenance care, but active care if something gets worse. And you could potentially move to reclassify if your condition changes significantly. So if a judge makes a determination as to your level of disability, or if your lawyer reaches an agreement with the insurance company as to your level of permanent partial disability, or LWEC is the other acronym we use, LWEC, loss of wage earning capacity, and you have not done a Section 32 settlement, yes, you could potentially reopen, reclassify, and get treatment that you need moving forward. Generally, you have 18 years from the date of closure to do that. Aside from a Section 32. Section 32, sorry, you gave up that right. They usually give you a little more money because you're giving up that right, but that's the trade-off there. A few more bucks, but your case is closed forever. If your case is still open or only partially settled, because sometimes we do partial settlements where we settle the indemnity side but leave the medical open, you might still have options moving forward. So you're locked in, but you're not fully locked in. There is a key. The last big mistake that I see, and it's the biggest big mistake that I see, is trying to do it alone. We do this every day. Workers' compensation attorneys do this every day. Personal injury attorneys don't do this. The guy who handled your traffic ticket 5 years ago really doesn't do this. It's a very specialized thing. I can't tell you how many times I've had discussions with other attorneys who work closely with us, who do personal injury and Social Security. And I start talking about, well, the person reached MMI and the judge found a 50% LWEC, and they look at me like I'm speaking French. It's a very specialized thing that other lawyers have difficulty with. The average layperson, and I'm not You guys are all great, and I'm sure you're all very smart people, but it's a very difficult thing to handle on your own. Without a lawyer, you are going to get, there is a risk, there is a chance that you're going to be taken advantage of by the insurance company's attorneys, and you don't want that to happen. You want to have somebody that's there for you, who's going to try to get you everything that you're entitled to. These insurance companies aren't just one lawyer, they have legal teams. And you don't want to go in there alone, and you want to try to get the most you can. Having an attorney, and this is not me pitching myself or selling myself. I don't need to do that. I'm doing this for you. Having an attorney is important. It really will help you in the long run. And you can call anybody you want. If you want to call me, I'm happy to talk to you. 212-406-8989. You guys are calling every day. I'm seeing people every single day, and I'm so happy to help. But you really should find somebody who can help you out with your case. That being said, I left my folder drawer open. Now, we talked about a lot of different things here with primarily non-scheduled loss of use cases. All these cases that we've been talking about are your head, neck, and back cases. They could be stroke cases. They could be heart attack cases. They could be total left knee replacement, fractured right ulna arm and back. When you have overlapping sites, like I said at the start, you want to really evaluate everything. And if you have sites that are in both categories, the scheduled category and the non-scheduled category, you really need to take a deep look into the case to see where that value lies and where you want to direct your case. If you have overlapping sites and you're still out of work because of the totality of your injuries, well, then a non-scheduled route is most likely the way you want to go. If you have a combination of scheduled and non-scheduled cases, but you did go back to work and you're working full duty and you're grinding it out despite your injuries, well, you might want to see what the value of those scheduled sites are, those arms and those legs. But when you have purely schedulable injuries, the arms, the legs, the knees, the shoulders, the hips, the ankles, the wrists, the feet, the hands, the fingers, the toes, all those things, compensation is handled differently. MMI is similar. You get your treatment, you get to the point where you're not going to get any better, where you've plateaued, where you've reached maximum medical improvement, and an assessment is done, and the doctors use the exact same form. The C4.3 form is still used, and they still ask, has the person reached maximum medical improvement, yes or no? A different section is filled out for schedule loss of use, but the determination for case value is very different. On a non-scheduled case, you are compensated based upon your level of disability and your lost time, and your earnings. So your earnings are used to determine your total rate of compensation. Your level of disability is where that rate of compensation falls, and your lost time tells us how much money you're going to get. You need to be out of work to get compensated. You need to be out of work, completely out of work, not just reduced earnings. Well, strike that. You need to either be out of work or working at reduced earnings at a lesser capacity to get benefits for non-scheduled loss of use cases. For scheduled loss of use cases, lost time is largely irrelevant. It does play a role in certain circumstances at certain times, but the value of a scheduled loss of use injury, an arm, a shoulder, a knee, is based upon your salary, your pre-accident gross weekly salary, and the severity of your permanent disability. Okay? Each body part has a statutory value. An arm, total loss of use of an arm is 312 weeks of compensation. Total loss of use of a leg is 288 weeks of compensation, payable at the total rate. Your particular percentage of permanent disability is multiplied by your rate of compensation, which is 2/3 of your gross weekly salary, to determine the value of that injury. If you are out of work for a long time and you get paid compensation for a long time, the insurance company gets the opportunity to take credit for all that money that they paid you while you're out of work at the end of your case. So going back to work sooner is better for you because you get back on payroll, you're back at work, you're making money again, and that money does not get credited against your final sum. So the quicker you go back, the quicker you put an end to those weekly compensation checks, the more money you get at the end because there's less deductions and you're making your salary again. You're kind of getting the best of both worlds. I'm not a doctor here. I'm not going to tell you to go back to work against medical advice. I'm certainly not going to do that. But as soon as your doctor clears you to go back to work, even if it is at light duty, you want to take advantage of that, because in the long run, it's going to put more money in your pocket down the road. And you really want to focus on that. That was my diatribe on schedulable injuries. And I want to now, let's jump into some questions here. How about those Knicks? How about those Mets? Ben, I received my MMI last week. Welcome to the club, Ben. The doctor confirmed my injury is work-related, but workers' comp denied my claim early on. I currently have no income. So if you received your MMI rating last week and you're still dealing with a denied claim, something doesn't seem right. MMI assessments are usually done for a scheduled loss of use. It's usually 1 year after your accident or 1 year after your surgery. So if a doctor's either the doctor's assessing you prematurely, or something's got to be done about your comp case to push it forward. And I'm talking New York. I don't know, Ben, where you're located, but something doesn't seem right here. You should certainly give me or somebody a call in your local area. Was your case denied, litigated, and you lost? Was it denied by the insurance company, but you're still pending litigation, trying to get it resolved? If you have no income, give somebody a call and get a push behind this case, because you certainly, something doesn't seem right and you want to get somebody involved here. Melanin, wow, chosen one. Thank you. That just seems nice. Retired UPS guy. Retired UPS guy, before I even read your question, you always have good questions, so bang. We're getting you in there. Now where'd your question go? Hello, Rex. The company submitted an offer. However, I'm leaving my state in California. Once I settle, can I still open a California state disability claim if you know, or how to case similar? I don't know. I don't know the specifics in California. I mean, how would that work in New York? You're settling a New York workers' compensation case. Can you still open it? Well, here in New York, a disability claim. Are you talking about a Social Security disability claim? Here in New York, I always say the term disability is used very interchangeably. Disability means a lot of different things to a lot of different people. When I hear disability, I think Social Security disability. But disability can also be, here in New York State, we have New York State temporary disability. There's private disability policies that people buy into and pay them while they're out of work. So disability can mean a lot of different things. But when I hear disability, I think Social Security disability, which is federal. You're saying a California state disability claim, which does not sound like it's Social Security disability. It's not federal, it's state. And if California state disability is something like New York State disability, New York State disability is generally not payable when workers' compensation is. One of them is payable for on-the-job injuries, workers' comp, and one of them is payable for off-the-job injuries, disability. So talk to your lawyer, really. Yeah, that's the best person, because I simply don't know California law, and maybe there's something I'm missing here. Felipe has actually, you know, in the world of big mistakes in the workers' compensation world, this is probably number one. This is a question that lawyers ask me probably 3 or 4 times a week. I got this client. He's really messed up. He fell off a ladder. He got run over by a truck. He got hit by a train, and he's working off the books. So he's out of luck, right? Wrong. Here in New York State, workers are covered. If you're working off the books, if you're working and you're getting paid under the table, if you're here illegally, you're still entitled to workers' compensation benefits. I can't, not only do people, the working world, the workers of New York State, the blue collar, great people of the state not understand this rule and this law. The lawyers of the state don't understand it. And only the people who do workers' comp really know what the truth is here. Worst time to cough. If you're working under the table, off the books, illegally, you're still entitled to benefits if you're injured. Hold on. This is allergies. I'm not sick. I know I've been sick like every week that we have a live. This is allergies. I never had allergies when I was a kid. I did it all, and now I'm getting old. There's grays coming in, and I'm getting allergies. And man, enjoy your youth, folks. So yes, to answer your question, if you're working under the table, off the books, and you get hurt, you're entitled to compensation. I actually just had we were out in Indiana visiting family. I went to the Indy 500, which is one of my favorite things to do. We went to a Knicks Pacer game. Me and my brother-in-law went to a Knicks Pacer game at the Gainbridge Fieldhouse. Unfortunately, the Knicks lost that game, and I was ridiculed, but I didn't take it lightly from the Indiana folk. I gave it right back to them. Let's go Knicks. But we were talking about workers' comp, and the question that was asked to me is, what if the person is a minor? What if the person is an illegal employee? Are they entitled to workers' compensation? Here in New York State, if you hire an 11-year-old who gets hurt, that 11-year-old is entitled to workers' compensation benefits just like anybody else. And not only is he entitled to workers' compensation benefits just like anybody else, he's entitled to double workers' compensation benefits. So just because you're working and you shouldn't be, or you're working off the books under the table illegally, you're here illegally, you're not a permanent resident, whatever you want to call it, if you're hurt on the job, you are entitled to workers' compensation benefits. Speak to a lawyer, get a consultation. It's free. You're going to be okay, and we're going to help you. So you certainly want to make sure that you know about that. Prosperous says her lawyer has done nothing, but seems like she works for the insurers. If you're not happy with your lawyer, if you're not comfortable with your lawyer, get a consultation from another lawyer. I hope you're not one of my clients. I try to do the right thing for each and every one of my clients. But having that comfort level with I say it all the time. It's super important that you're comfortable with your doctor, because being comfortable with your doctor is going to allow you to recuperate and get better quicker and to a better level. And having that comfort level is just as important with your lawyer. And it's a weird dynamic with the lawyer. I have a couple of clients who get on the phone. I just had one today, and we're settling his case with a great settlement. Every time we talk, it gets to the point that we are screaming, and I'm like pulling my hair out. And the conversation always ends with, "That's the way I talk to people." Well, this is him telling me, "That's the way I talk to people. You're my man. I trust you 100%. You're going to get this done for me." So people have different personalities, but being comfortable with your lawyer is super, super important. And I don't think she works for the insurance company. But if you're not comfortable, find somebody who makes you comfortable, or get comfortable with them. Jeff says, in a settlement, besides money, can you negotiate time added to pension years, continued paid insurance premiums? What are the things that are not obvious and can be used in negotiating a settlement? Great question. Generally, no. Okay. No. Certain times with certain self-insured entities with union ties, certain things can be negotiated for. But generally speaking, it's here's money. Here's the money to the point that everyone's satisfied. And when do you know a settlement is the right number? It's when everybody's unhappy and everyone goes their own separate ways. Very, 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 very rare are things like added pension years and paid insurance premiums. I've never done it. I've never seen it. It's very, very rare. Is it possible? Anything's possible. We got some IGers coming in here. Let's see what we got. My thumbs are so fat. They get in the way. Twizzy's just telling me, okay, Twizzy's getting $650 a week, 100% by $650 bi-weekly, 100% disability, 8 staples to the head. So you might have a facial depending on where that scarring is. What kind of settlement will I get? That's a very good question. I need a lot more information. What level you're at with your case. If you're in New York, you want to give me a call, Twizzy3X, call me, 212-406-8989. Ask for Rexy3X. My doctor, this is Jay Wizzle now. My doctor ruled an MMI, workers' compensation was to have a hearing to a final decision. A few days before that, the insurance company requested an IME, awaiting a letter in the mail. What are your thoughts on that? What it sounds like, your doctor has filed his report giving max medical improvement. The insurance company probably gave it a whirl to try to work it out, or maybe they didn't, but they're sending you to see their doctor to get their own opinion. It's par for the course. It's not shocking. It's not bad. Keep the appointment. Let's see what they have to say, and you'll get through it. Just Angie. My phone is cutting off There it is. I'm scheduled for, now I cut myself off. Let's go back to the old ways. Let's go back to the way it was. I'm scheduled for an MMI next week. So it sounds like you're going for a permanency evaluation. The facility where I'm scheduled to go called me yesterday and asked me if I was coming to my appointment. I responded and asked, why would I not show up? Okay. I feel like there's more to that one. Angie, I'm going to need future knee replacement per the doctor. Yes, I'm scared because I've already had 2 surgeries scheduled for MMI next week. It sounds, I'm trying to get all of Angie in one shot. There you go. Doctor said I couldn't do my prior job. Been in medical doing my job for 20 years. Knee will need to be replaced now, not now due to age. I don't want to switch jobs. So things like knee replacement, MMI is a funny thing when we're talking knee replacements, especially in younger people. We have a client, he's in his 40s. He's right around my age, with really banged up knees. And the doctor told him that he needs knee replacement. He doesn't need it right now. He can get by. He's in pain, but he can live his day to day. He's got creaky knees and bad knees. And, he's kind of come to terms with it. But he knows at some point in time in the future, he's going to need a knee replacement. And what do you do under those circumstances? Do you settle the case and be done with it and just, that's it? And when it's time for knee replacement, hope that you have enough money to pay for it, or what? Well, here's what we discussed, and here's how we handle it, because you're going to need significant surgery. And God knows how much a knee replacement costs today. And God knows how much more it's going to cost in 5 or 10 years from now. So what are we doing? We are looking to get that case resolved ultimately with a finding of a schedule loss of use. Either we stipulate, we agree to a schedule loss of use finding, we let the judge make a decision. But we're going to avoid a Section 32. Why? Because a Section 32 is going to close that case forever. This individual is going to need a knee replacement at some point down the road. And with a stipulation or determination on schedule loss, you can potentially reopen the case. So, Angie, I know you're conflicted and confused. Sorry. But maybe if you need a knee replacement and you're not ready for it, you get your permanency evaluation. You get your schedule loss of use findings. I don't know what your injuries are. I don't know if you have category 1 and category 2. I don't know what you're looking at here, but maybe if it's just schedule losses, reach an agreement, get compensated for your schedule losses, leave that opportunity to reopen open to you. If it is a combined case with schedule and non-schedulable injuries, get a permanency evaluation and, move forward. But you want to make sure you leave the door open. Super important that you have a lawyer here. Super important that you have a lawyer here, because I have spoken to potential clients in the past that come to me and they say, I didn't have an attorney and I was hurt and I had a bad back and a bad knee and a bad this and a bad that. And they came to me with an offer and it seemed like a really good number. And the judge approved it. And by all, it sounded good. And I settled my case. And now I need a knee replacement. What am I going to do? And did you have a new accident? Nope. Did you have anything intervene that could potentially be the cause of the need for this knee replacement? Nope. Well, you're kind of stuck. So it's super important. And this is my mistake number 8 that we talked about just now, that you have a lawyer. You're welcome. Call your lawyer. Andrew, do you have a lawyer? I hope you do. You need one. You're in that. There's so much confusion and crap going on at this stage of your case that you want to have a lawyer. You have to have a lawyer. You don't have to have a lawyer. I should never say that. You really should have a lawyer. Whew. It's 4:00. A couple more, and then I got to sign off, folks. But Ty all day. Ty, you're awesome. I've been on comp for 4 years, multiple injuries, non-schedule included. I've been approved for SSD, and I've been to the IME 23 times already. Holy shit. Should you push for MMI? I don't know. You've been on comp for 4 years. One thing you want to consider, there's a little sectional law called 15.3W. So you might want to start considering it, and you might want to certainly talk to your lawyer about it. 15.3W basically says, what's the time frame? 130 weeks, 2.5 years. So we're looking at non-scheduled loss cases. If you are disabled for any period of temporary partial disability beyond 130 weeks after your date of accident, the insurance company can take credit for those weeks against your final permanent partial disability. What does all that mean? 130 weeks is 2.5 years. Okay, fine. So you go 2.5 years after your date of accident. Boom. There's a fine line in the sand right there. For any weeks of compensation that you receive from that point up until MMI permanency. So you have a window, 2.5 years after your accident up until the date that you are classified with a permanent disability. For any weeks that you receive partial compensation for a partial disability in that period, the insurance company gets to take credit for those weeks against your cap. What's the cap? If you have a 75% permanent disability and you get 400 weeks of compensation, and there's 50 weeks that you were paid partial in that window, they're going to take it off the back end. You're only going to get 350 weeks of permanent disability. Okay? So you've been on comp for 4 years. That 2.5 years has come and gone. It's very possible that 15.3W applies in your case. It's confusing. I know. It's really not that bad. But you might want to have a sit down with your lawyer to discuss the implications of 15.3W on your case, and maybe you might want to start considering settling. If for no other reason than to go for a 24th IME, that's a lot of IMEs, my friend. I can only imagine what the insurance companies spend on those. Dwayne, hey. Would a pain management report of no MMI reach a 65% mental health report? Dwayne, you lost me. Would a pain management report of no MMI reached and a 65% mental health report help increase my settlement? 3 years in workers' comp, 2 fusions, knee arthro. Can I get a tip to close or keep going? It's hard to say, yeah, go this or go that. It's hard for clients that I represent for years, and I know the ins and outs of their case to say, do this or don't do that. I like to lay out the facts, lay out the options, and help them make a decision that's best for them. Because Dwayne, I don't know who you are. I don't live in your shoes, and I don't know. Are you single and live in the bachelor life, or do you have 4 kids? I don't know. So it's hard for me to say what you should and should not do. Talk to your lawyer, and if you don't have one, you can call me, and I'll do my best to help you out. 212-406-8989. Paul Vasquez always has nice things to say. Thanks, Rex. You always deliver. I'm about to reach MMI for my L5S1 fusion. Catherine is talking smack. She's very good at that. Hi, Rex. Does the insurer normally send the Section 32 check by priority mail? No. They usually send it in the same envelope that they send all your other checks. And if you were getting benefits through direct deposit, usually comes that way. Is it tier or is it tear? Do I have an office in Mississippi? I don't. I would like one, but I don't. I'm not licensed in Mississippi, folks. I'm only licensed here in New York State. But I think we do have a firm that we work with in Mississippi. If you have any questions, call me, 212-406-8989, and I'll do my best to set you up. Truth Seeker always has great questions. I have a question, and it's a great one. What typically happens after a rating on injuries? Truth Seeker, you didn't give me the whole question. It's a great first half of a question, yes. Get a cool mist humidifier to put in your office, help with the dry cough. Thank you. Nothing helps. Nothing helps. Hi all day. My pleasure. Here's a good, so I see, what if you've been released but still have pain and the surgery center won't release medical records to your lawyer and she gives up? Your lawyer doesn't respond. That sounds odd. Go to the surgery center and ask them for your records. They're your records. Ask them for a copy of your records. And if your lawyer doesn't respond, find a different lawyer. That's just not right. I think it's gonna be my last one because the throat is just bad for your kidneys. What's bad for your kidneys? The doctor said at our last meeting that if my pain remained the same, he would release, or if it increased, he would send me to another doctor within their system. Was a bit confused about that comment. So basically, from what it sounds like he's saying, and I'm not, you should ask him to explain anything that you don't understand, but what it sounds like he's saying is if your pain is remaining the same, then the plane in Spain or the rain in Spain, If your pain is at the same level, it sounds like you could potentially be at maximum medical improvement. But if your pain is worsening, maybe you're not, and he wants to send you to another specialist, pain management or something along those lines. I got see now. C. Hampton. Hello. A year later, a workers' compensation appeals judge. Is this New York? Because there's no workers' comp appeals judge. There are appeals commissioners, unless you went to the third department. But the judge was favorable on your behalf. What's the next process? Here in New York, read that decision, that appellate decision, that board panel decision. And it'll usually tell you in the last paragraph, this case is remanded for further consideration or further development of the records or for awards consistent with the decision. It usually tells you in the decision what the next steps are. All right, folks. I have to go get a cool mist humidifier because I'm dying over here. But I do want to say, let's go Mets. So far, we've taken 2 or 3 from the Dodgers, and that's fantastic because who really wants to see the Dodgers win anymore? We're back on top of the world. Let's go Mets. Are you lisinopril? No, I don't think so. I don't know. No, it's definitely allergies because when I take that one allergy pill, I'm like feeling great. And this morning I ran out of the house without taking it. It's my own damn fault. Folks, I want to thank you for all these fantastic questions. I'm so I answered your question, Robin. I'm not on lisinopril. Darn it. Did you ask another question? You guys know how to tug at my heartstrings when you skip my question. I feel bad. I'm sorry. I want to answer every question. I cannot answer every question. I do everything I can to answer every question, but you make me, I'm confused about where I am with this case and what I can do outside of dealing with workers' compensation doctors. Listen, that's a very common place to be at. And we have clients all the time that say, settle my effing case so I can go and get holistic acupuncture from a shaman who tips his needles with ox blood because it's going to help me. Listen, you do you, okay? The Workers' Compensation Board medical treatment guidelines dictate the treatment that's approved and authorized by the board, and shamans and ox blood are not in there. There's a lot of things that are not in there, and people like to do, and it really comes down to comfort. Just like being comfortable with your doctor is going to get you better results. If you're a holistic person that thinks certain things are going to be better for you, you have that confidence, they're going to help you most likely. I'm not one of those type of people, but you do you. People do what's right for them. That's why we have choices in this world. That's why I'll never tell a client, you need to settle your case. I'll very rarely. Sometimes you get those ones that you just need to be jumped on, but more often than not, I don't tell somebody yes settle or no settle or yes surgery or no surgery. I try to discuss it with them so they understand what the options are, the pros and the cons, so they can apply it to themselves and make a decision that's best for them. You don't live in my shoes. I don't live in your shoes. I can't make that decision for you. So if looking for medical care outside of the workers' compensation world is something that you think is going to help you, well, understand the ramifications. It's not going to be part of your case. Insurance is not going to pay for it. If something, God forbid, goes wrong, it's on you in whatever capacity. Maybe you have private health insurance that might help out, but you are taking risks. But if it's what you choose to do, God bless you, go do it. So, and we see it happen a lot. A lot of clients say, and I'm not going to say a lot of clients, but there are people that say, I've had enough of this crap. I'm sick of going to the doctor's office and sitting in the waiting room for a half an hour so the physical therapist can put me through 5 minutes of stretching and moving and this and that. I'm done. I want to move to Tibet and have somebody else do whatever they do to make me feel better. And that's totally okay. Totally up to you. Folks, I want to thank you so much for your time. I want to thank you so much for your great questions. I gave you a lot of information today. It's cumbersome. It's bulky. It's confusing. And I understand that. And that's why I'm trying to boil it down. And that's why we don't do one video on MMI. That's why we talk about this crap every time we're here. This is a topic we discussed almost a year ago, last August. And the responses to it are still coming in. The views on that video are still going up, which makes me understand what you guys need. And if you have questions about it, call me. hold it for the next time. And like I always say, I try to answer every question I can. I love you guys, and I want to help everybody that I can. But I understand it's cumbersome and confusing, and the whole system is. It's a legal matter, and I had to sit through how many years of law school with droning in my ears and computer clicking away just to get to the point that I can start getting a grasp on this to help out other people. Nobody can expect a guy who just fell off a ladder, got hit by a car, fell down a flight of stairs. The rolling chair, I think, Kat, we got 2 rolling chairs this week. The rolling chair has been an ever popular injury. I think it was one of the most predominant injuries in New York State. The rolling computer chair, when you go to sit and you catch the edge of the chair and the chair flies out from behind you and you fall on your butt and you smack your head on the desk. We've had a couple of those this week. But nobody can expect the person who goes through that and is now hurt and is not working and has kids to feed and has mortgage to pay and has whatever to now become a legal scholar in the world of workers' compensation. So call a lawyer. You don't have to call me, but call somebody for help. The consultations are free with any lawyer. By law, we cannot charge you for a consultation. Call a lawyer, get some input, get some advice, get some direction, and hopefully they can help you do the best you can and maximize those benefits. If you want to call me in my purple shirt today, this is the my City Connect jersey, purple. If you want to call me, 212-406-8989. I'm always here to help. I love you guys. You're all fantastic people. And I'm signing off, and like 50 more questions pop up. Oh, I love you guys. So, no, I'm not. I'm just a regular guy here to help. Call if you need help. 212-406-8989. With that, love you. Thank you. And I hope to see you guys next week. I actually, Cy, if you're there, Baxter, bark once if you're there. We're doing next week, folks, next Wednesday, June 11th. Let's shoot for 3:30 p.m. 3 p.m. How's that sound? Next Wednesday, June 11th, 3:30 p.m. Save those questions that you guys just bombarded me with at the last 5 minutes of my life, and I'm going to get to everybody I can. We're working on some really good stuff to help you out here. Some good topics, some fun stuff, and some informative stuff as well. So next Thursday, June 11th, 3:30, as I bang my face into the microphone. Love you guys. See you next week. Be safe. Bye-bye.